Thank you. Welcome to the Joint Committee on Municipalities and Regional Government. This is our fourth hearing of the legislative session. It could be the fifth, but I think it's the fourth. Good afternoon. I'd like to first introduce to my extreme right, Paul Gottlieb from the House. We have Representative Suzanne Whipps-Lee, Representative Kevin Kuros, and Representative Paul LaRue. We may or may not be being joined at some point in time here this afternoon from some of our colleagues from the Senate side. If I could just have a couple of housekeeping items that we can share with folks here in the audience. Generally, the practice of this committee, like most committees here in the House, and we generally will take elected officials out of order, so I will be calling on colleagues that come in during the course of this hearing. I would also like to ask folks to have a number of folks here this afternoon, which is always a good thing. When people come to the State House to voice their opinions and ideas on matters before this board, before this committee, that we try to keep our comments to 3 minutes. And I know that it becomes a little more difficult when there is a panel of 2 or 3 or 4 speakers before us, and if we're giving each of those folks 3 minutes apiece, that sort of extends the timeline a little bit. So we can try to keep our comments, if you're the second or the third person to speak in that panel, try to keep your comments to matters that have not already been addressed by previous speakers. That would be greatly appreciated. I think you'll all appreciate it as much as we will, so that you're not here for the entire afternoon, although Boston's a great place to spend time. Maybe not stuck in this room with me. But anyway, I appreciate all of you coming, and we have a lot of information, a lot of matters before us here this afternoon. What else? Okay, I just ask that we try to pay attention to those that are speaking. If you have a need for conversation, if you could please take it outside, that would be greatly appreciated. Oh, I know the other matter. I wish everyone happy holidays. So, thank you again for coming. We'll try to move this process along as quickly as possible. So, with that being said, I see Representative Chairman Minsky in the room. Want to come forward?
Thank you, Mr. Chairman and members of the committee. This should only take a minute or two. And thank you for taking the other turn. I'm here to speak in favor of House Bill 1855, which I filed along with 18 of our colleagues. And this is a bill that was initially proposed by the Metropolitan Area Planning Council, and I know that Mark Grayson from MAPC will be here in a few minutes to also speak in favor of it. And it's something I'll say that only a municipal finance geek would love. But it's something important. It's one more tool in a toolbox for a municipality, and it would allow cities and towns to create parking benefit districts and have a separate accounting of the funds, the revenues collected from parking meters and other parking lots and parking garages. It's something that the city of Worcester has already done by a home rule petition on a bill that was reported favorably out here. And as we like to say, as Worcester goes, so should the rest of the county. So this bill
knows what he's talking about.
So this bill is a local option bill. It would allow a city or town, in a town's case like mine, town meeting, to adopt this provision and then create a parking benefit district. It's an economic development tool that would be helpful for my main town, the town of Natick, because we have some parking issues in downtown Natick, and we would like to be able to create a parking benefit tool. Again, it's a local option. It doesn't force anything at all on any city or town. They would have to adopt it, and it's in keeping with the spirit of local home rule, allowing city or towns to be able to do what city or towns do best, which is to know their own municipalities to be able to create a parking benefit district. So with that, I would ask for favorable action on House
Thank you. Any questions?
Thank you very much.
Thank you, Mr. Chairman, I appreciate it.
Thank you very much.
Representative McGonigal. You have a panel?
I do, Mr. Chairman. Good afternoon, Mr. Chairman. Committee members, thank you for allowing us to testify here today on behalf of Home Rule Petition 3828 and 3831, which would benefit the City of Everett greatly. Today I brought, Mr. Chairman, our Mayor, Paolo Di Maria, his Policy Director, Catherine Rollins, and the City's Legal Counsel, Jonathan Silverstein, and the Mayor, as testimony, and I hope after his testimony and the questionings that we get a favorable recommendation out of this committee. Thank you, Mr. Chairman.
Good afternoon, Mr. Mayor.
Yeah, Mr. Chairman, and members of the committee, thank you for taking this time today for us. Thank you for the chance to testify for you today in strong support of 2 home rule petitions that are very important to the city of Everett. Again, I'm joined by my policy director, Captain Rollins, and also my counsel, Jonathan Silverstein. But also to thank our representative, President Joseph McGonigal and Senator Selby Domingo for their help in bringing these home rule petitions to you today and for the work they do in the legislature every day on behalf of the people of Everett. House 3828, an act that authorizes the city of Everett to establish a linkage fee revolving fund. Everett is a densely populated urban area experiencing rapid growth and redevelopment. And we would like to assemble the right tools to ensure that we appropriately maximize the benefits of development for our residents, protect and enhance quality of life. The bill before you today will allow Everett to establish a linkage fee revolving fund. A linkage fee is a charge on a new development to pay for its offsite improvements that both necessitated by and benefit the new development. Linkage fees have been around across the country since the 1960s. In Massachusetts, several cities have adopted linkage fees, most commonly related to affordable housing, creation, and job training. Boston was the first to establish a linkage fee in 1987, followed by Cambridge in 1988, Medford in 1989, Somerville in 2005, and Gloucester in 2010. As written, this bill will allow Everett to establish a linkage fee revolving fund. If the legislature approves this bill, an impact fee schedule will be set after a carefully considered analysis. Money from the fund will be used to improve streets, parks, and public recreation facilities within the city, and much, much more. I'm happy to work with legislative delegation and members of this committee to move this legislation forward. Is it okay to speak on the next bill also? Absolutely. House 3831, an act relative to the creation of a community enhancement fee stabilization fund in the city of Everett. Under the host community agreement signed by Everett and Wind Resorts in 2013, and thank you to all of you for that great legislation. The city is due to receive $30 million in the community enhancement fee during the construction of Wind Everett. These funds will be used for capital improvements projects within Everett. The city is currently in the second year of a 5-year capital improvement plan, focused on many long-term needs such as reducing fossil fuel consumption, decreasing deferred maintenance costs, reducing heat and electricity expenses, and creating efficiencies by means of technological advances and automation. The city also has very significant needs for new public facilities, including fire stations, police stations, schools, city hall, parks, and cemeteries. The first of the community enhancement fund payment from Wind Resorts, a $5 million payment due within 30 days of when the construction begins on the project, is expected this spring. We need to create the community enhancement stabilization fund in order to be able to accept the money. Therefore, I respectfully ask the committee to act swiftly to give this bill a favorable report. Thank you again for the opportunity to be here in front of you, and I'm here happy to answer any questions that anyone may have. Thank you, Mr. Chairman.
We're happy to take any questions, so we'll open questions and answers.
Okay. You're all set. Anybody have any questions? We're good?
All right, thank you very much, and thank you for testimony. Appreciate it. Thank you. Have a great day.
You're welcome.
Representative Gonzalez.
You have a panel, correct?
Thank you, Mr. Chairman, and thank you, committee members. I'm here to support a couple of bills. The first one is House 3818, which is gives the right for the city of Springfield to lease the North Riverfront Park property to the presently used rowing club, which allows inner city kids to learn about rowing as well as how to advance their skills, not only in the rowing area, but also in schools and throughout the community. So we hope that you can support the House petition for that. Also, I'm here on Senate 1080, which is to have a commission on the status of women and girls, and the distinguished group of panelists that are here today, including our school committee representative that is here, will more eloquently explain why this is important. We hope they consider this favorably.
My name is Tahira Antuwadud. I'm from Comte County, I'm the state commissioner.
Good afternoon. My name is Denise Hurst. I'm from the great city of Springfield, like Representative Gonzalez. I am also an elected member to the Springfield School Committee, and also am a commissioner for the Mass Commission on the Status of Women.
I'm Lucy Hartree. I'm from Northampton, Massachusetts, in Hampshire County, and I'm a former statewide commissioner on the status of women, and a former school committee member in Northampton.
I'm Nancy Rosenbaum. I'm the Vice Chair of Metro West Commission on the Status of Women, and I'm from Ashland.
Hi, I'm Bonnie McCracken from Amherst. I am chair of the Housing Committee for the Amherst branch of the NAACP.
Good afternoon. Thank you again. On behalf of the Massachusetts Commission on the Status of Women, we strongly encourage the Joint Committee on Municipalities and Regional Government to support House Number 1867, Hampshire Franklin County's Commission on the Status of Women, sponsored by Representative Ellen Story, Senate Bill 1080, Camden County Commission on the Status of Women, sponsored by Senator Ann Golding, and House Bill number 3463, an act establishing an Eastern Regional Commission on the Status of Women and Girls, sponsored by Representative Gloria Fox. The Commission stands for fundamental freedoms, basic human rights, and the full enjoyment of life for all women. In its mission to provide a permanent, effective voice for women across Massachusetts, the Commission is specifically empowered to study, review, and report on the status of women in the Commonwealth, inform leaders of business, education, healthcare, state and local governments, as well as to serve as a clearinghouse for information on issues pertaining to women. The Hampshire Franklin Commission on the Status of Women, the Hamden Commission on the Status of Women, and the Eastern Regional Commission on the Status of Women and Girls bills are well aligned with our mission, as it allows for the establishment of effective advocacy and advancement for the women of each aforementioned county. The issues pertaining to women in those regions, such as domestic violence, female graduation rates, and poverty will be addressed, and the necessary steps to improve overall quality of life will be implemented. The Massachusetts Commission on the Status of Women has regional commissions in Berkshire County, Bristol County, the Cape and Islands, Essex County, the Metro West Region, and Worcester County. Each of these regional commissions reports on findings annually, which helps to increase the effectiveness of those organizations designed to aid women in those particular areas. These commissions have served an invaluable resource to the women of Massachusetts. Some of the many issues that have been addressed include affordable and quality health care for women, child care services, sexual abuse and assault prevention, and educational youth policies. Despite the significant accomplishments that each commission has made to advance women of the Commonwealth toward equality, there remains a gap in coverage in pockets of Massachusetts. We hope that the information we have shared with you will help you guide your decision, and we strongly encourage your support on these 3 bills. Thank you for your time and consideration.
Good afternoon, my name is Tahira Matuladud. I'm an attorney, I live in Springfield. I have a practice in Chelsea, and I practice family law in 4 Western counties with a significant area of my practice being assisting women who are victims of domestic violence. I do serve as a state commissioner here. Commissioners who are appointed to the Hampshire-Franklin County Commission would have several important responsibilities in order to bring about change for women. Some of the issues that must be addressed include the above average rate of poverty in Franklin County, particularly with regards to women over the age of 65, the prevalence of domestic violence in Western Massachusetts, and a female graduation rate that is lower than the state average of 86.5%. Commissioners who are appointed to the Hamden Commission would have similar responsibilities to address issues specific to the county. Some of the issues include the county's highest rate of women without a high school diploma, that means 16.2%. Higher rates of adolescent mothers than the state average, 12% of all births to adolescent mothers compared to the state average of 5.4% of all births to adolescent mothers, and a higher poverty rate than the average for women, that's 11.4%. Establishing a Hampshire-Franklin Commission and a Hamden Commission will cover the existing gaps in commission coverage and ensure that women and girls from these counties are given a seat at the table and have their voices heard. By encouraging women to participate in this community, this bill will foster a greater sense of involvement and help inspire the next generation of women leaders here in the Commonwealth. So I ask you to support that bill. Thank you.
As I said, my name is Lucy Hartree, and I work at Tapestry Health, a multi-service reproductive health care agency in Western Mass for almost 30 years. I won't repeat the statistics as they've been eloquently elaborated on, and they're readily available. I'm going to tell you why I'm here advocating for the creation of a Hampshire-Franklin Commission on the Status of Women. The most meaningful part of the work that I did as a statewide commissioner was attending the hearings throughout the state where we heard from women and providers of health and human services and other local women's commissioners about their issues, about their struggles, about the things that were important to them. And all those comments were made annually to the reports that we would make to the state, as well as legislative and policy initiatives. That was the most rewarding part of my work. The reason I didn't remain on the commission is the reason creating a Hampshire, Franklin, and any other local commission is so important. On many occasions during my tenure, I had to turn down offers in order to come to the State House to testify for 3 minutes or less. Not that I don't appreciate the opportunity, but it's a 2-hour trip, and one way, and 2 hours back. And that's not realistic for most women in most walks of life. So having local commissions where creative women, hardworking, interesting, contributing women can participate in a commission is so important. And I really do urge you to consider that very important aspect of creating local commissions. Thank you.
You can move that right on. That will go to you. There you go.
Okay, thank you for the opportunity to speak before you today. As I said, I'm Bonnie McCracken. I'm a resident of Hampshire County, and I reside in Amherst. It's not just my work on the NAACP that brings me here, but I'm a mother, I'm a grandmother, and I'm a great daughter-in-law, and that's their futures are why I'm here today. Also, the female population in Hampshire County in 2014 was at 53.4% of its total. And in Franklin County, it was 51.2%. Hampshire County actually has the highest percentage of female residents for its population in all of Massachusetts, but we don't have a commission. We are the only Western Mass county besides Hampton County that has no local representation on the Commission on the Status of Women. And we're divided amongst 5 Senate districts and 7 House members. Thank you, Susanna, let's leave. And we, none of our communities out here are linked by state highways. It would allow our voices to be stronger and to serve as a bridge between our rural communities and legislators that represent this region. As I said, I'm chair of the Committee on Housing for the Amherst branch of the NAACP. Every call I receive about housing issues is from a woman. Low-income families with housing subsidies residing in Hampshire County are restricted by HUD to pay rental values that are not reflective of the local market. Women in my community often pay more than 30% of their income on housing. Furthermore, women still face discrimination in the mortgage market. Some women heads of households have been targeted for high-rate predatory mortgages. Borrowers with predatory mortgages are far more likely to be foreclosed. Thank you for your consideration of these bills and the opportunity to speak before you. Thank you.
Good afternoon. My name is Nancy Rosenblum, and I'm the Vice Chair of Metro West Commission on the Status for Women. We were created in the last legislative session, and I'm here today to express our Commission's support for House Bill 1867 and Senate Bill 1080. In the years since the Metro West Commission has been created, 9 women from Metro West region have come together with the shared goal of giving voice to women and girls in our region. Many of us had limited political experience. The establishment of our commission created an opportunity for us to learn more about the political process and what we can do to give voice to the women in our communities who do not have access. In our first year, we wanted to strengthen our ability to advocate for women and girls in Metro West by listening, learning, and informing ourselves about the issues that matter to women and girls in our region. We had our first hearing in September. We heard from service providers, we heard from educators, elected officials, researchers, as well as hearing personal testimony. Many of the difficulties facing women in our area are the same issues across the state. And they've been mentioned: the need for child care, affordable housing, services for addictions, sexual assault and cancer, domestic violence. But we also heard issues that were particular to Metro West. Metro West has the only female prison in the state, and we wanted to make sure that women in the justice system's voices were heard as well. I brought a newspaper clipping if anybody wants to get a better flavor of our hearing. And we're now in the process of setting up informal a learning tour and to meet with women who did not show up for our more formal hearing. So for the reasons that everyone has said, I, on behalf of the Metro West Commission on the Status of Women, urge you to report out favorably on the act establishing a Hampton County Commission on the Status of Women and Girls, and an act establishing Hampshire Franklin County's Commission on the Status of Women. Thank you for this opportunity.
Thank you all. Any questions from the panel? Go ahead, Fred.
Thank you, Mr. Chairman. Just a general overarching question. I represent 4 towns in Central Mass, 3 in Worcester County, and 1 in Norfolk County. And I'm part of, my district is part of 2 separate commissions on the status of women, the Worcester County and then also the Metro West. Metro West. And I guess the overarching question is, why don't we do like all the ones that are remaining? Because there seems to be momentum here, and it seems like we're doing them piecemeal. And I would just pass the message on to the overall leadership that it may make sense to take a look at any holes in the map that we have that we may want to introduce something for next session.
Any other questions? Thank you all very much for making the journey down from Western Power to stay. We appreciate it. Thank you. I'd like to welcome Representative Badaro from East Boston, who is joining us on my right, and on my left, my good dear friend, Representative Garvey. Is it Arlington? From Arlington. So we've heard from a number of folks already here. I'm going to go a little bit through this list to make sure that those bills that we've gone through already, that there are still folks in the audience that would like to speak on either of the bills that have presently been heard. House Bill 3818. Any additional individuals wishing to speak on that bill? If not, we'll close that portion of the hearing. House Bill 3855. Anyone here to speak on House Bill 3855? There's no sign-ups for that. No one signed that shit, sir. All right? Oh, if not, we'll close that portion of the hearing. Representative Provost, I'm sorry, I'm getting ahead of myself here. Please come forward. Sorry about that, Rep.
Thank you very much, Mr. Chairman. I appreciate being taken out of turn, and I don't mind waiting while you clean up your agenda.
Thank you. Come forward.
Thank you. I'm Denise Provo, state representative from the city of Somerville, which since 84-85 has been a sanctuary city. And I am here today to speak in opposition to House 1856. I don't usually speak in opposition to bills, but I think there's a great deal of misunderstanding surrounding this bill, which I might be able to illuminate. I was attorney for the city of Somerville that oversaw the petitions sent in the Board of Aldermen to resolutions, I should say, to designate Somerville as a sanctuary city. And I think I can unpack some of the assumptions that are made in this bill for you, Mr. Chairman and committee members. The premise of this bill seems to be that cities and towns are required to enforce federal immigration laws, and that if they do not, they should become ineligible for state aid. I would point out that the federal government enforces the federal immigration law these days, primarily through ICE, Immigration and Customs Enforcement. Municipal police are not federal employees. They have no training in immigration law. They have no reason to be trained in federal immigration law. And while they may act cooperatively with ICE when requested from time to time, they are not federal employees, and enforcement of federal immigration law is completely beyond their jurisdiction. So I don't know where this idea comes from, but it is embodied in this bill. Another provision of this bill sort of restates the prohibition on receipt of local aid by saying that it shall cease to be dispersed upon verification of the failure of the city or town to comply with federal immigration laws. The only compliance that I can think of also came about in 84-85 when all employers had to inquire of all prospective employees what their citizenship status was and provide a social security number. I assure you that the city of Somerville, like every other employer in the state, files all of its IRS required forms, which is really IRS compliance. They're like state elected officials, local elected, and many appointed officials take the same oath that we do to uphold the Constitution of the United States and of the Commonwealth and all of the laws that are made in accordance with flouting the law, which of course would be unlawful and disorderly and not the work of municipalities. The final provision of this very short bill is that failure to comply with federal immigration law shall include, but is not limited to, a declaration of sanctuary city status. And once again, a declaration of sanctuary city status, I have to say, is mostly feel-good rhetoric. Somerville decided to adopt its sanctuary city resolution at a time when a great many refugees from the war in El Salvador were coming to Somerville. It was a way of showing that things were different here than they were back in the violent and lawless and war-torn place from which these people were fleeing. And it relates entirely toward the attitude of the city, to its discretionary actions, and really has no bearing whatsoever on federal immigration law, as it was, Salvadoran refugees, immigrants at that time, were given temporary protected status by the U.S. government, and many of those same people who came to Somerville in the 80s from El Salvador are citizens now, and still living in the city. So that's what sanctuary city resolutions do. They are not and have never been considered by the federal government or anyone else that I know of to be violative of federal law, and I'm sure if they were, the federal government would let us know. So I wanted to give you some background on how things work in a sanctuary city and what's contained in a sanctuary city resolution, and to assure you that Somerville, like the other municipalities in the Commonwealth, is quite cognizant of federal law and in compliance with it. And I thank you.
Thank you. Any questions? Thank you very much, Representative.
Thank you.
Appreciate it. Back to the agenda. House Bill 3865, or Senate 2066. Anyone here wishing to speak on that? And that would be an act establishing and appointing the superintendent of streets in town and the town highway. Hearing none, we'll close that portion of the hearing. Senate 2042. Anyone here wishing to speak on Senate 2042? And that's an act relative to the Gloucester Fisheries Commission. Hearing none, we'll close that portion of the hearing. House 1834. That is an act relative to community regional impact between neighboring towns. Hearing none, we'll close that portion of the hearing. House Bill 1845, Senate 1096. Hearing none, we'll close that portion of the hearing. House 1857. An act to allow municipalities to exempt small projects from the prevailing wage law. Hearing none, we will close that portion of the hearing. Senate 1069. An act to end the stigmatization of out-of-wedlock births. Hearing none, we will close that portion of the hearing. Senate 1084. An act relative to constitutional rights. Hearing none, we'll close that portion of the hearing. Senate 1087. An act to enforce snow removal requirements. Hearing none, we'll close that portion of the hearing. Senate 1105. An An act relative to confidentiality of reports of rape and related offenses. Hearing none, we will close that portion of the hearing. Senate 1211. An act providing training for certain local boards and commissions. Hearing none, we will close that portion of the committee. Of the hearing, excuse me. House 1867, House 3463, and Senate 1080. We have already had comments on those three issues or bills. If there are any further individuals wishing to speak to those, if not, we will close that portion of the hearing. We will now go to House 3883, an act providing for a selectman town manager form of government in Wellesley. How about David Murphy and Marjorie Freeman? Good afternoon.
Good afternoon, thank you, Mr. Chairman and members of the committee. My name is David Murphy, and I currently serve as Chair of the Board of Selectmen in the town of Wellesley, and I'm joined also by Marjorie Fryman, who is the Vice Chair of the Board of Selectmen. We are here to speak in favor of House Bill 3883. Currently, Wellesley has a centralized form of government. We have an Executive Director of General Government who has information technology, IT, as well as finance reporting to him. But we also have 9 elected boards, each of which has departments with staff. These department heads are hired and managed by those boards. A year and a half ago, town meeting in Wellesley voted to establish a town government study committee to look at our form of government and make recommendations for change. This committee did extensive research and presented its findings and recommendations at a special town meeting that began early last month in November. The main recommendation was to create a selectman town manager form of government in Wellesley. The special town meeting extended over 8 evenings, and the debate was extensive and vigorous. Numerous amendments were proposed, and a few of those were accepted. In the end, 60% of town meeting members voted to authorize the filing of this legislation. It is worth noting that if the General Court approves this special legislation, it will come back to Wellesley for the voters to approve or disapprove at a townwide election. So the town of Wellesley is requesting your favorable action on this legislation to create a selectman town manager form of government. Thank you for allowing us to speak on this issue, and we welcome any questions you might have for us. Go ahead.
Hey, Mr. Chair, I just wanted to make sure I heard you correctly. You said there were 8 nights of meetings for this one topic?
That is correct. And each evening was scheduled for 3.5 hours. There is a break in the middle, so call it 3 hours, 24 hours. And
So it's safe to say the community is pretty well invested in this whole discussion.
Well, I think so, and you may hear some other later in this hearing. You may hear others who continue to oppose it.
Was there a quorum of present each of those 8 evenings that you met?
That is correct. Right? There's a quorum at each of those meetings.
And with the upcoming vote that you're hoping to have, should this be approved at the House level here, is it a simple majority?
That is a simple majority.
Okay, thank you.
Okay, thanks.
Any other questions? No? Good. Thank you. Masha Testa?
Yes, interaction between other speakers who want to bring it on to.
Fine, sure.
Wellesley. I'm also an elected Board of Health member for the past 12 years. I'm also have been on the faculty of the Harvard School of Public Health for 28 years, where I run the Masters in Public Health program there, and I'm also on the executive committee of the Mass Associates of Health Boards. I'd like to defer to our first speaker, and if we could go in order that we may. Thank you.
My name is Jean Annell. I'm a lifelong resident of Wellesley, town meeting member. I want to thank you for letting me speak today. And in my career, I served as this state's Medicaid director, as well as advising a former mayor of New York City and consulting to the federal government on a range of government issues, just by way of background. Today, I and my colleagues here urge you to give an unfavorable report on this proposal, to send it back to our town for more work. This proposal makes sweeping changes in our town's history. Yet it was rushed through our town process. It is far from having consensus. It's premature, in our view, incomplete, as far as the research goes biased and one-sided, and there is not consensus yet. The town is deeply divided on this proposal. It barely passed town meeting after a vigorous debate in a 60-40 split. Fully 40% of our town meeting, which is over 250 representatives, opposed this change. And I repeat, it is the most sweeping reform in our town's 124-year history. It will have to go to a referendum in the spring, and there will be a very contentious battle, further fracturing our formerly very unified town. There are many bases for the proponents and what they are wanting to do, but there was a very big point that they made that is basically untrue, it's incorrect, that our town was lagging behind all other towns in our basic structure. We're not lagging, and we're not that different from other towns. We have a beautiful grassroots democracy in Wellesley. It's based on the traditional New England government of a town by its citizens for its citizens. We've accomplished amazing things in our town, and if you came to our town and saw what we've done with all of our elected boards, you would be amazed and thrilled at how so many people, so many passionate volunteers can accomplish so much. We have an award-winning recycling facility. We built a new high school. We recently purchased 41 acres of pristine land. All of this took tremendous research and work and coordination by many passionate volunteers. So our system works. We're not in a crisis. We don't need to do this so quickly. But some people prefer more control. They prefer a more centralized system. And we feel, and there are 40% of town meeting feels, that this was rushed through by a small group, and that we need more time to achieve consensus. There are some changes we'd like to see, everyone would like to see, improved coordination among our boards, a town-wide strategic plan, but we haven't reached consensus on how to achieve this. And we definitely don't want to degrade this precious democracy that we have in Wellesley and dismantle a beautiful system of governance by town citizens without consensus. We were starting to find consensus, but we are far from it right now. And there's no rush. There's no emergency. There's nothing broken that calls for a rush job. Please recommend Nancy's
Thank you. I've already done my introduction, and my concern here is with the language of the special act granting powers to the town manager without full recognition of the jurisdictional authorities of elected boards, and in particular the Wellesley Board of Health. As you know, when a legislator delegates a job to a local body, that particular body becomes an agent of the state. Certainly Massachusetts General Laws, Chapter 111 and Section 31 enables boards of health to enact and enforce reasonable public health laws in the form of regulations. These regulations stand on the same footing as town bylaws, state statutes, and state regulations. Similar to the statutory autonomy of school departments, Massachusetts General Laws, Chapter 111, Section 27, gives boards of health exclusive authority to hire, fire, supervise, and establish contracts with officers, agents, and assistants they deem necessary to execute health laws and regulations. In contrast to these reference laws, Section 3B of this special act grants the town manager the sole authority to hire, appoint, fire, manage, and supervise all departments except for the school department and municipal light department. Furthermore, it grants authorities to the town managers to reorganize, consolidate, and abolish a department and would only need the approval of an effective board or town meeting. While a board may veto an appointment, no other authority granted by the Commonwealth is acknowledged. So I believe that as written, the special act town manager involvement in these duties appear to be in direct conflict with Mass General Laws, Chapter 111, Section 27. Now, I reviewed the 16 towns in Massachusetts that have the proposed form of government, that's representative town meeting, and also town select and town manager. And of those, only 2, Needham and Winchester, have elected boards of health, where the conflict, you might imagine, will be greater than when you have an appointed board of health by a town manager. But reviewing the charters of those 2 towns, what I found that both actually recognize the jurisdictional authority of boards of health. In particular, the town of Winchester recognized the full authority as was given through Chapter 111 without any other comment. And in Needham, although the town manager appoints the director of the Board of Health, with regard to the clauses about consolidation and dissolving boards of health, they require the approval of the affected board. There's no or if qualification where the town meeting could actually override or do in place of a board of health. So recent governance efforts in public health have been to move more toward greater regionalization in the state level for fostering integrated states. Federal and global response. So I think we should be moving in this direction. And also, I have given you a letter I've sent to every member of the committee which cites some of the case law that sets the precedent that we are talking about. And also want to say that we did propose an amendment to enable us to maintain our jurisdictional authority, and it failed with 55% being in favor, but it was very close. Thank you.
Good afternoon, ladies and gentlemen. My name is Jerry Murphy. I'm a Wellesley resident for 48 years. I was a member of the school committee, town meeting member, and was a member of the faculty of Wellesley High School for 41 years. I think this proposal, there are a number of things wrong with it. I think it's undemocratic. That's not to be taken lightly. We have a town meeting situation, as I mentioned to you, where citizens can speak at town meeting members vote. We have an advisory board, we have a board of selectmen. And this will centralize. And in centralizing, it takes away avenues for citizens to air their views. Centralization is not a good idea in this case. If we centralize, that has a trust us influence to it. And that can be a dangerous precedent. And it runs against the history of the town. We have open dialogue and discussion. As I understand it, there is no job description for the town manager. As I understand it, there is no budget. How can we proceed on that basis? I think it has been said in town meeting and by some authorities that government is getting too complicated in Wellesley. So what we need to centralize. centralizing that, as I said earlier, takes away some of the elements of democracy. And government is not, if it is getting complicated, where is the evidence to indicate that? We don't do that. Somebody has said, or repeated, that it's getting too complicated. Fair enough. Where's the authority that there is one? I think in a town like Wellesley, things that are complicated, we have a population that is highly educated, and we can learn. We can have experts explain things to us, and we can learn. The elected officials, if we're dealing with a complicated issue, the elected officials, they have a fiduciary responsibility, moral responsibility to explain that policy. If they can't explain that policy, that's their problem, and that's another issue. They can explain the policy, they can ask a lot of questions and so forth and so on. So we have an open dialogue going in Wellesley. That's been the history of the town. But it's much more than that. It's democracy in action. And I think also that to have an argument stating that government is too complicated is at best elitist. And at worst potentially dangerous. This report is incomplete. It lacks budget detail. It lacks responsibility. If I was still teaching, I would give this enough.
So folks, I know all of what everyone has to say is incredibly important. I'm just going to ask people to try to maintain the 3 minutes time. Excuse me. No.
I have something prepared on very quickly and then we'll.
Thank
you. My name is Ann Marlanza and I'm an elected member of the Wellesley Library Board of Trustees and active member of the Legal Women Partners. But I'm also a town meeting member. I'm here today in that capacity to give voice to the 40% of town meeting that voted against the special act we considered today. We ask you to take a careful look at Bill H383 because the process to get this bill to you today was rushed, divisive, flawed, and most importantly, incomplete. The special act and bylaws contained in this bill are not ready to take approval. Town meeting never discussed the possible changes to government until we were called to the special town meeting in November. In the 2 months leading up to the special town meeting, there were roughly 4 released versions of the special act and bylaws, with new versions distributed each night at town meeting. Town meeting members read hundreds of pages of documentation and were left seriously confused about what was being discussed. The shortness of time resulted in a special act and bylaws that were fraught with legal errors and inconsistencies. The lack of time spent prior to town meeting vetting these legal documents resulted in citizens making amendments to fix obvious legal errors on the floor of town meeting. We met for 8 grueling nights. Each night was contentious. There were over 20 amendments. No elected board beyond the Board of Selectmen stood in complete support. There was a split on our advisory committee. Questions on the financial impact were left unanswered. In the end, we passed with only 120 votes, not a majority of town meeting. And this yes vote was predicated on the assumption that town meeting would successfully conclude the process after passing all the bylaws. But town meeting was disbanded before we could finish our work. The special act has references to policies that haven't been approved. The bylaw for the budget process, the linchpin of the town manager's power, was never discussed or ratified. Town meeting is now required to reconvene in February in order to complete this work. At this point in time, with the 60-40 vote at town meeting, a majority of elected officials came against this legislation. Many respected town leaders appalled, and many town meeting members feeling marginalized. It is obvious that this process has gone seriously awry. The town of Wellesley needs someone to take a rational, careful, and reflective look at these documents in this situation. The argument is not that we shouldn't take a step forward in how our town is managed. It is that we shouldn't overhaul our government change for well, so please help us do this correctly. We ask for your unfavorable report in this bill. Thank you.
Thank you. Anybody have any motion?
Thank you, Mr. Chair. Not a question so much as just, I guess, general commentary and give you one person's perspective on this. A little bit of background on myself. I was on the Board of Selectmen in a very small town, Uxbridge. And I was either the first or second board elected under a new charter that had changed the balance of power in Uxbridge from a very strong Board of Selectmen model to a strong town manager model. There, obviously with 3-year terms, there's some overlap with people who were elected under the prior model, with myself who was elected under the new model. And I'll caution everyone that change is not always comfortable, and it happens, and we all struggle with it on a daily basis. But my perspective on things like this, and I'm not speaking on behalf of the committee, but only as one member of this committee. I've served on this committee for 5 years now. And my perspective has always been, if a town wants to do something to itself, and it's not illegal, I think we as a committee need to let the town do it to itself. I mean, it's not for you to weigh in on Wellesley politics, okay? As long as what you're proposing is legal. The young lady raised issues that she's concerned that perhaps some components of the bill as presented are not legal. And I submit that that's precisely what the Attorney General review of things that come out of town meeting is for. And so I'm not an attorney. I would always defer in cases of these types of issues, like we did in Uxbridge, to the Attorney General's ruling on those types of things. So, with all due respect of all the opposition, it appears the meetings were posted, due process was followed. You may disagree with the process, and many will always disagree. You'll typically never get 100% agreement on anything. The old adage of the enemy of good is better, and the enemy of better is best, and the enemy of best is perfect. And if you're going to wait till this is perfect, it'll never happen. So just my own personal perspective, and this is not a statement on any of the testimony that you all provide or anything else. Is I see a bill come before us that went through due process. I don't have a horse in the race. I don't live in Wellesley, and it appears to be legal. And if it isn't, the AG will. So I do understand your request for unfavorable action, but I'm just inclined to support it just because it appears that due process has been followed.
Thank you, Mr. Chairman, and thank you for your testimony today. Just to echo my colleagues' sentiments on this, around election time, I often say we get the government we deserve for better or for worse. So it's a winning statement whether I win re-election or if I lose with re-election. And it's it's in that similar vein. It sounds like this did go through a process. The process, it's not a super majority, but there is a majority of folks who approve of this. And like I said, a lot of people share the sentiment. If what the community wants to do to itself, that you should be allowed to do to itself. Which we echo when I said a moment ago, we get the government we deserve for better or for worse. And might be one of those I told you so situations, which could be satisfying in the future. So, nothing else. Mr. Chairman.
I'd actually rather not do that. I would rather not. I would not.
Thank you all very much. Yes, sir, real quick.
Well, we may be getting the government we don't deserve.
Only the voters of Wellesley can determine that.
As my colleague pointed out, there are the gaps in information with
In this system of democracy, people get the government deserve better or for worse. It's the collective three.
Are there any other individuals who wanted to sign up for 3883? That was the bill that we were just debating. Any other speakers here on that particular piece of legislation? Hearing none, we will close that portion of the hearing. Thank you. Senator Lee, you want to go? Is he all set? All right, so he stepped up. All right, Senate 1111, Robert Cohen. And Joshua Davidson.
Thank you, Mr. Chairman, members of the committee. Robert Cohen, representing citizens of voluntary law enforcement, Massachusetts, and Josh Davidson. We're here to answer any and all questions. I had a very quick meeting with General Day of this one in his office to review formal legislation. It's very cut, dry, very simple, and we thank you for your consideration today. We hope that you will be favorable.
You may just probably give us a little bit of information that everyone may know.
The purpose of this legislation is to protect the volunteer law enforcement throughout the Commonwealth that volunteer their time and efforts to cities and towns all across the state. There's approximately 1,200 of these individuals that serve in Massachusetts for no compensation. They are reserve officers, auxiliary officers, special officers for the cities and towns all across the Commonwealth, and they perform all sorts of functions, crowd control events, freedom parenting exercises, ceremonial activities, lots of functions that cities and towns can't afford to have these people do, but these guys do it voluntarily, and they're trained, they've gone to the academy, and they enjoy doing this. The intent of this legislation is just to give them the workman's comp coverage in case something happened. If they were out directing traffic at crowd control, or something, God forbid, happened, and then highway is over, these guys are volunteers. And we talked to the unions, and we talked to the Massachusetts Police Association, and they don't oppose this legislation because they think it's a no-brainer. You've got folks performing valuable service for no cost to the cities and towns. At the very least, they can extend the envelope of protection for them. And that's what the intent of this legislation is.
Thank you.
Thank you.
Any questions? Thank you very much.
Thank you, Mr. Chairman, for making the committee for your time.
Senator. Good afternoon.
Good afternoon. I'll be very brief. I'm here to speak on two home petitions for the city of Everett. House number 3828 and house number 3831. And I know you heard from our mayor previous to this point. I think that was still long ago as well. I just want to add my support to these two bills. The first one is creating a linkage fee, which will allow our city to put money into infrastructure improvements and capital improvements in our city. As you have heard previous to this point, Everett is a very dense city, and there's a lot going on right now, a lot of development that's happening. And these fees will go a long way in making sure that those developments don't really impact the community and only enhance the community in a positive way. And the other bill is for the community agreement with the city of Everett and Wyndham Resort. So they had to, as part of the host agreement, they put up $30 million a year, with the first payment coming in 3 installments. And this will set up a mechanism for that money to be taken into the city and spent for our community for positive improvements for our city. For capital improvement plans, infrastructure improvements, for programs that will help with fuel assistance, and a whole list of issues that will impact the community in a positive way. So this is me just coming here today to add my 2 cents in support for these 2 bills.
Thank you.
Thank you, Mr. Chairman.
Thank you very much.
Thank you.
Good seeing you. An act to support the equitable utilization of third-party consultants and land use. We have Patricia Baumer, Ian Bailey. This is House 1847 and Senate 1102. Good afternoon.
Good afternoon. Mr. Chairman, members of the committee, thank you for the opportunity to testify this afternoon. We recommend Patricia Baumer, I'm the Director of Public Affairs for the Greater Boston Real Estate Board. We, along with the Massachusetts Association of Realtors, filed this bill. My colleague Justin Davidson was unable to be here today, but they would like to register their support for this bill as well. In a nutshell, this bill is a product of a working group that our members created to try to address some of the low-hanging fruit when it comes to reducing costs for development. Senate 1102 and 1847 is something that we think is a very reasonable, fair bill that will help to streamline the process and address some of the issues around development. During the development process, third-party consultants are often used and retained by local boards and commissions to review applications. During this process, the cost is absorbed by the applicant without any limit to the scope of the work. This legislation it preserves the rights of municipalities to retain consultants, but establishes some reasonable standards for the use and selection of third-party consultants. In a nutshell, what it does is encourages the town to establish a list of third-party consultants with 3 at a minimum, in which the developer could pick from that list to try to streamline the process a little bit. They'll also, in addition to having them non-less than 3 consultants that they would be allowed to pick from, the Board of Commission was, it was necessary for them to apply, employ consultants, the developer use it from that certified list. And it simply asks them to coordinate the boards and commissions so that there's no overlap or duplication among multiple boards and commissions. So it doesn't change the status quo. The municipalities would be allowed to employ third-party consultants, which the developer paid for, but it certainly tries to streamline the process and establish some minimum standards for the use of these third-party consultants. I'm pleased to have one of our members here today, Dan Bailey, who's an attorney at Kearsarge in Boston, and does this for a living. So with that, I'll sort of yield my time to him so he can speak from his experience on this issue. Thank you.
Thank you, Mr. Chairman. Thank you for the opportunity to speak here today on this important legislation. I have over 25 years of experience representing property owners, developers, institutions, and municipalities on land use matters. I routinely appear before planning boards, zoning boards of appeal, conservation commissions, and the like. I was even a member of a conservation commission at one point. And I'm very accustomed to the development process here in Massachusetts. This is important legislation, and it would help streamline that process quite a bit. It does 2 things from a practical perspective. The first thing it does is save time. Under the current law, what typically happens is an applicant will submit a permit application that will go to the permit granting authority, and 40 days later, when they have the first public hearing, then they'll request proposals for peer review consultants. What this would do would be to allow the applicant to select from a list at the same time that they were submitting the application, saving it anywhere from 45 to 90 days in the process. The other thing it does is it makes it fair. There's a set list of consultants. The developer can select from that list, which has been pre-vetted by the town, and get up to 3 different proposals. We think this is important. We think it would be very helpful to the process, and thank you for your time here today.
Any questions?
Thank you, Mr. Chairman. I'm curious, how does a new consultant get on this list if somebody's looking to enter this market as a, like for a startup business? I used to do consulting before I was, not for anything that you guys are probably interested in, but just curious.
What would typically happen is the towns that do this well already do this to some degree, and on an annual or every other year basis, they'll go out with a request for proposals for consulting services, and they'll maintain a list. So it gets updated on a regular basis, like anybody that's contracting on a regular basis with a public entity. That local entity will decide, are we going to do this every year, every 2 years, and update the list.
So the list is not going to be static, it's not going to be exclusionary. Is that written into, I don't see it written into the statute, the bill here. Just kind of concerned that like it could be a static list, which would be a barrier to entry for new businesses.
I think that's a fair comment. You want to maybe build in some requirement to regularly provide opportunity to update the list.
Yeah. Take that up with the committee.
Thank you very much.
Thank you, Chair.
Is Mr. Gracie's still here. 1855 and 1094. There you are. How are you?
I'm well, Mr. Chairman, thank you. Good afternoon, Mr. Chairman, honorable members of the committee. For the record, my name is Mark Grayson. I'm the Executive Director of the Metropolitan Area Planning Council, which is the regional planning agency serving people who live and work in the greater Boston region. I am here today to speak in favor of this legislation, which is numbered Senate 1094 and House 1855, an act relative to parking advancements for the revitalization of communities. Parking is one of the most thorny and difficult issues that any community faces. There are always multiple demands for the very limited streetscape. Communities have a responsibility, obviously, to provide for driver safety, for traffic with a limitation, as much limitation as possible of congestion, places for people to put their vehicles. They are also required to try and deal with streetscape improvements, with issues of safety, with questions of preserving and improving pedestrian access and safety, bicycle parking and bicycle travel, and a whole host of other things, all on whatever the size of the street actually happens to be. Today, more and more of our communities are approaching this issue by trying to redesign their streets to make sure that pedestrians, bicyclists, and drivers can use it jointly, and they are installing new and modernized parking systems. In some cases, this means sticking with the meters that they have, but trying to make sure that there is greater consistency and a plan behind what the charges are and in what places, similar signage, and an understandable situation where if you go from one place to another, it's either the same rules that apply, or you can see a reasonable reason why the rules might change as you move, for example, to a corner or a busier part of town. In some cases, people are purchasing new, more modernized parking systems, which operate with credit cards or other systems of that kind, and allow people to buy certain periods of time on the meters, to do so when they have cash in their wallets, etc. I'm sure all of you have used. In some cases, perhaps you've been frustrated by some of those systems, but I am glad to say there is a lot of rationalization occurring in the marketplace these days, much better systems, most of the kinks are being taken care of, and many communities want to install meters of that kind, and we provide them with advice in doing that. In other cases, communities are moving to demand-sensitive pricing, where the price of a half hour at a particular spot is not the same at all times. It might be one thing at 6 in the afternoon on a weekday. It might be something different at 2 o'clock in the afternoon on a weekend. And the prices are scheduled in such a way that parking always accomplishes its primary goal, which is to make sure that with a little bit of a search, you can actually find a space. So that you don't have a parking space area that's completely empty because it's overpriced, or you don't have a parking area that is so limited, or in terms of price, that it is full all the time and no one can ever find a space. Invoking these new systems, any of these new systems, requires public discussion and public assent. And in order to do that, one of the things that we very often hear from communities is that they would like the parking revenues to be sent back into the community, not just to pay for the meters, but streetscape improvements, pedestrian improvements, and other safety amenities that will serve the general neighborhood. That is not currently clearly allowed under Massachusetts law. This bill will allow that to be the case, allowing cities or towns through a proper process to establish a park district, PARC, and then to use the monies collected there for a somewhat broader array of issues, all within that locality. It's completely local option, but it's a modern way of addressing the parking issue and creating some common understanding between the town administrators and the residents or businesses in that area. I might note in closing, Mr. Chairman, that the Senate today engrossed a bill passed previously or reported favorably by this committee, Senate 2012, an act relative to off-street parking in the city of Worcester. We always know that Worcester is one of those cities in Massachusetts that often leads the way. And this was the case here as well. In this case, the city of Worcester bill would allow for almost exactly the same situation in regard to a particular city garage in the city of Worcester. We commend the committee for its support of this bill and the Senate for passing it. We hope the legislature as a whole will pass it. And we hope that in short order, you will provide to the other residents and businesses and municipal officials of the Commonwealth similar capabilities in their communities. Thank you very much.
Thank you. Any questions? Thank you very much, Tom.
Thank you.
I see.
Where is Worcester?
Some people like to think it's Western Mass, but it isn't. It's Central Mass. That's right, you are. It's the second largest city in New England. Did you know that, Sean?
I'm well aware.
Senate 1086. Actually, Mr. Comte.
I'll be very quick, Mr. Chairman, members of the committee staff. My name is William F. Coyne, Jr. I am appearing here as legislative counsel to the American Chemistry Council, and to introduce to you a white paper that should have been circulated to you. I apologize that our subject matter expert was unable to attend today. He will be available sometime in January, and I would like to try to schedule some meetings with the committee and staff for you, Mr. Chairman, at usual convenience. Slightly different subject matter than you've been dealing with, but an important subject matter nonetheless. Thank you so much, and if you do have that white paper, we'll follow up promptly.
Fine. Thank you. Thank you very much. Thank you for your patience.
We have Senate Bill 1097, an act relative to the annual reports of cities and towns. James?
Mr. Chairman?
Oh, you, sir.
Finding yourself.
Very well. You testifying on two bills? Are you testifying on two bills?
I will. I want to thank the committee for, the chairman of the committee for hearing this bill, and Senator Ives for sponsoring it for me. I heard the bill's passage, and I hope you recommend it favorably. As a matter of background, my name is James N. T-Burge. I live at 8 School Street. I'm a retired state employee. I worked for the Division of Banks as a MIS director. Before that, when it was called taxation, now revenue, I worked in programs and analysis, so I'm a DP guy. But during the day, at night, I was a 5-time chairman of the Board of Selectmen, FinCom, town meeting member, school committee, all that stuff. And when they changed the chart, although I was elected on that day, so, for another 3-year term, they did change the chart. I am also, just as a disclosure of the principal in, I think 2000 plus, it's an advocacy group that, works on solutions, problem solving, and I have developed, and it works, local government in a microsecond. After spending 40 years watching government firsthand and as a practitioner, I sat down and did my lifelong dream in 2.5 years, and now you can do it in a microsecond. All you gotta do is enter the data, which for me is difficult. Why am I here? Well, this act is to amend the chapter of the law to chapter 40, section 50, to include cities in the submission of the annual report. As a practitioner, one appreciates all the time and all the efforts of the employees of the various departments, and you've heard all of the departments talked about today, and their efforts. And for years, as as chairman of the board, I could always come to the library, and I always dealt with the library as a member of the banking commission. One of my responsibilities was to file the statutory reports with the clerk, house clerk, and the secretary of state, and the depository library downstairs. And I was quite dismayed when I came and I realized that the cities do not have to comply with that requirement. So when we changed charter from town to city, no longer was that report, required to be filed, that annual report with the State House Library. So I made the change, and I filed it, I think, 3 sessions ago with the senator. And I'm hoping, as a matter of historical record, one time I had to go there and I looked at reports 1890 on our library, and that was of value. And I think that the members of the House and the Senate can appreciate having that there as a historical document. It's a backup for the cities and town in the event that something happens. So I don't think the cities should be exempt, from that particular requirement. It's such a valuable document, and it should be, there historically forever. And it isn't available. And I find it now where, the deadline dates are October 1, and to date there's no annual report. Last annual fiscal year, it didn't show up till January. So this is becoming a very easy way to circumvent it. I would like to see it hardwired in the process that cities as well as towns file this report. So, as a historical integrity, if anything, archival, backup, I want the hard copy there so everybody can see it. You guys and gals can go down there and give it a look-see if you want to know something about Ainsley and what are the particulars in the departments over time. So, as somebody who has been a practitioner for many years, and who's been very fortunate since his retirement to teach local government, state and local, and relational database, to do my lifelong project, I really hope, I urge its passage, and that you look upon this favorably. And again, I thank you for hearing this issue. You've heard so many, and they're all important. And I associate with all of them almost. So the thing is, having that much time, in grade, and also a United States Navy veteran, I thank you for the time, your patience, and the fact that you may pass this and recommend it to the House. Thank you. Any questions?
So I have a quick question. So the cities today, are you talking, do they have to do the report and they're not sending it, or they don't do the report at all?
It appears that there's no requirement to send it to the State House Library.
But they have to do a report.
I don't know all the situations. I'm sure they do.
Okay.
They have to do something.
Okay.
But there's no requirement for the cities, as I read it, to send it to the State House, to the Fingal Library as a historical document, as they have since whenever. So I was dismayed at that, and when you can look at the inception of our library in 1892, and I read all the historical facets because of a local issue, that's pretty important. And having that dual location and being sure that in the event of a catastrophe of some kind, it's there, it's a backup, maybe archived in addition. Thank you very much. Any other questions? Hey, thanks.
Thank you.
Thank you very much.
Senate 1100, an act providing for a workforce housing financial plan. Sheila Miller.
Hello. Good afternoon, Chairman O'Day, members of the committee. For the record, my name is Sheila Dillon, and I'm Chief of Housing for the City of Austin. And I'm here on behalf of Mayor Walsh, and I'm here to testify in support of S1100, an act providing a workforce housing finance plan. The bill is sponsored by Anthony Petrocelli, and I also want to note that a companion legislation has been filed in the House, 2541, sponsored by, Chairman Kevin Honan, and is pending before the Joint Committee on Revenue. One of the largest housing challenges that the City of Austin is facing is providing housing for our middle class. Like our lower income households, we also have a problem with the middle class being able to stay in the city. Folks that have lived there for years, if not decades, as rent and sales prices rise. So as part of the mayor's housing plan they released last year, he called for the creation of 20,000 units of housing that would be affordable to the middle class. But unlike our affordable housing production, which we do with a combination of city and state and federal funding, we don't have a lot of funding to create middle class housing. So we're really looking to put together packages of incentives so developers will do the right thing. Residential properties already benefit from tax policies in Boston. Boston discounts the tax rate for housing. It's nearly 2/3 less than the rate for business properties. But to provide additional stimulus for the production of workforce housing, the city proposes a tax incentive program that will provide assistance during the project construction period through lease-up. State law provides for a similar tax incentive structure, STAs, for commercial real estate, but unfortunately, the current STA incentive is not available to developers of residential property. We first thought we could use it, but then upon further review, we felt we really needed to file for something separate. So this bill allows municipalities to designate workforce housing special assessment zones in areas that present opportunities for increased development of middle-class housing. And when we look at not downtown, because it's become so expensive, but areas outside of the core city, next to the transit, we really see these areas as being wonderful areas to build more housing that's affordable to the middle class. But developers are having a very difficult time making the numbers work, so we don't see enough production in these areas. This legislation would provide relief for the 2 years during construction, and then a graduated tax for the 3 years that a development may take to rent up. 25% in year 1 of occupancy, 50% in year 2 of occupancy, 75% in year 3, with 100% tax being paid in year 4 going onward. The municipality must adopt a plan outlining the program, including target areas, minimum number of units for a project to qualify, maximum rents, etc. And in exchange for the exemption, developers would have to execute an agreement with the municipality regarding details of each project. So for developers, the savings would accrue in the critical early years, and we were told by multiple developers, we've been meeting with them a lot on incentives, that this tax relief would help make projects feasible. So we're hoping it would be a modest reduction in the taxes that the city realizes, but we think it would go a long way to really incentivizing and increasing this important housing stock. So I want to close with that, and I want to thank you for allowing me to testify. And once again, we don't have a lot of incentives and tools to build middle-income housing because the focus has been on housing the most needy. But if we can't keep the middle class in our cities, the cities will not be as healthy or as desirable. Thank you.
Thank you. Any questions?
Just a comment, Mr. Chairman. Director Dillon, thank you so much for testifying on this bill. This is so critical, and I know in my district in East Boston, we're undergoing gentrification at a very rapid pace, and we have a nice stock of luxury housing for those who are more affluent, and there's a lot of affordable housing being built for those who are in the lower income brackets, but what's being lost is those in the middle class. Many of those folks were born and raised around, and this sounds like something that would address that, so thank you.
Thank you. It's very true. Thank you.
Thank you
Thank you so much.
Thank you. So we will proceed to House 1856, an act relative to sanctuary cities and towns. We have a number of individuals that have signed up, and we will begin with Reverend Maria Tina Virgo. Please step forward.
Thank you.
Good afternoon, Mr. Chairman. My name is Reverend Maria Cristina Macias-Cribon, and I serve the First Parish Unitarian Universalist Church in Brooklyn. I am also a member of First Parish Unitarian Universalist in Cambridge, and so I hold them both communities very dear, and where I minister to our congregations there. And I'm sure that the people who have signed
signed up to speak will address the issues of democracy, the issue of constitutionality, and around this bill that makes so many assumptions about the role of local law enforcement, where they would be in a city that has passed a resolution to be recognized as sanctuary, to be punished in essence for expressing something that really welcomes all immigrants and wants to afford everyone due process. I will address the issues that concern ministers and concern communities of faith with regards to the potential for fear driving people, vulnerable people, both undocumented, documented, citizens, non-citizens, underground with respect to reporting sexual assault, domestic violence, and abuse in the workplace. We are in the so-called business of providing pastoral care to people, and the issues that come before us precisely address issues of reporting, and I'm speaking of U.S. citizens. A lot of the crimes that I've mentioned before go greatly unreported, especially if they have to do with sexual assault and domestic violence. We know, and I don't have to cite statistics, that it is something painful, it is something that people don't readily do, even in the best of circumstances. Even when people are citizens, we know that these crimes go unreported. Our fear as members of the communities of faith, of cities that have declared their intention to be hospitable and for local police enforcement to have the right to choose how to divvy up their resources, we find that bills of this type really increase fear and paranoia. And if there's already difficulty for victims of workplace abuse or domestic violence or sexual assault in coming forth and reporting to local police officers, sheriff's offices, the fact that a sanctuary city like Cambridge, like Boston, like Somerville, like Chelsea, would be known as a sanctuary city and would be punished for doing so, making all people, all citizens, afraid of reporting crimes, but literally creating two tiers of citizenship and two classes of people. And so I'm here to remind people that today is Human Rights Day, and that we hope that our cities would recommit themselves to uplifting the human rights of everyone and to consider the negative impact of forcing and deputizing police officers and sheriffs into becoming immigration agents, driving people underground and not being able to access due process and justice.
Thank you very much. Thank you. John Roberts.
My name is John Roberts. I live in Cambridge, one of the targeted sanctuary cities. I'm now retired, but for 32 years I was executive director of the ACLU of Massachusetts. During that time, I testified in these chambers on many issues, supporting some, opposing others. But I must say, I have rarely seen a more vague or legally problematic piece of legislation than 1856. And I speak in opposition to its passage. This legislation provides for the withholding of unrestricted general government funds to any city or town that, quote, fails to enforce federal immigration laws, unquote. What laws are these? Specifically, what federal immigration laws are municipal authorities required or even legally allowed to enforce? If the state is threatening to withhold funds, it needs to be clear about what constitutes an actionable violation. This legislation does not meet that requirement, except in one instance: the mere declaration that a city or town is a sanctuary city. The only specifically stated violation of this legislation is the use of the name sanctuary. No showing of illegal action or violation of law is required, just the use of the name sanctuary, a biblical concept that conveys a welcoming protection and support to the suffering stranger. That mere designation with no required showing of violation of law presents the state with an enormous legal problem that needs to be prepared to defend in court if this legislation becomes law. It is difficult to accept that this is serious legislation. It appears to be more of piling on to the anti-immigration hysteria being perpetuated by certain political leaders and presidential candidates in this country at this time. Massachusetts should have no part of this anti-immigration ploy and should not embarrass itself by the passage of this ill-conceived, legally indefensible bill.
Thank you. Excuse me, sir, I think we have one question.
That's just a comment. Just want to let you know this legislation's been around since before the current crop of political candidates pushing this type, so I'm not really sure which came first, chicken or the egg, but you know, the bill doesn't have my support, it makes you only better.
Alice Wolf?
I'm not Alice Wolf, but I have a letter from Alice Wolf.
You do? That's terrific.
Okay. I'm Vicky Steinitz, and I was for many years a constituent of Alice's. Alice writes, I am truly sorry that I am unable to testify personally today on H1856, an act relative to sanctuary cities and towns. I'm strongly opposed to the bill and ask that the committee not move it forward. Massachusetts has an important role in history as a safe haven for those who have come to reside within our borders. In that history, those who have so chosen have often been people from other lands, and they have often come fleeing from circumstances under which none of us would want to live. Sometimes that has been persecution that could lead to death. At other times, that has been economic circumstances that would dire. It was during very troubled times in El Salvador in 1985 that a number of El Salvadorans arrived from Cambridge, and some received sanctuary at the old Cambridge Baptist Church. These immigrants faced oppression in El Salvador and probable death. As a result of these new residents in Cambridge and their need for protection, the Cambridge City Council voted to make Cambridge a sanctuary city. I was the chief sponsor of that resolution. The Cambridge City Council has voted at least twice to renew that status as circumstances change. The Commonwealth should not sanction its municipalities for actions they take to protect their residents. Furthermore, in issues related to immigrants, municipalities have really to deal with the federal government in whose bailiwick immigration law is. In these troubled times, it is more important than ever to support and honor the Commonwealth's long-standing status as a safe haven. It is fear-mongering to do otherwise. Thank you for your attention to my concerns. Sincerely yours, Alice Wolf, former state representative.
Thank you for bringing that on behalf of our former colleague. Appreciate it. Dr. Julia Kochner?
Kohler.
Oh, sorry about that.
Thank you, Mr. Chairman O'Day. Thank you, distinguished members of the committee. My name is Julia Kohler. I'm a pediatric infectious disease staff at Children's Hospital, and I'm the chair of the Immigrant Health Committee of the Massachusetts chapter of the American Academy of Pediatrics. And I'm here to testify in opposition to the bill before you, 1856. And to explain why, I want to start with telling you a story of a patient, of one of my patients, recent patients. This summer, I was meeting the patient and his mother as he was, and I should say all identifying information is changed. 4-year-old preparing for bone marrow transplant and undergoing testing, and they had driven from their home to Boston to get this testing done, and of course it's a fearful time because some very painful weeks and months lie ahead. So I just exchanged, some supportive words, and other staff were coming up and greeting them because this child had been in the hospital a lot. And mother said to me, well, I was really scared today driving in here because you know what could happen. And she was referring to the fact that she does not have a driver's license because she's undocumented. And I have to tell you that the reason I have become very concerned with this issue is that I have seen many children suffer the consequences of the fear and of the actuality of what this mother was expressing, which is the family being broken up and the child losing a parent to deportation. That is why my colleagues and I are becoming active on this issue. It's very harmful, not just to the child who has an undocumented parent, and 80% of these children are United States citizens. It's also very harmful to their family members, their neighbors, their classmates, and all who hear, oh my God, Johnny's father was taken and he's gone. So this fear drives parents not applying for support for their children that the children are entitled to as citizens, such as early intervention, food support, etc. It puts parents like this mother in front of the choice: do I risk arrest and give the police, turn me over to ICE deportation, or do I take my child to the medical appointment? So this child actually did well during bone marrow transplant, but then rather far out, weeks out, like close to getting ready for discharge, suddenly developed a terrible complication. And tragically, just as that happened, mother's fears were realized. So I should say that the parents took turns in cooking at home cooked food for this 4-year-old, and bringing it in every day so that they would eat better and do better nutritionally. And in fact, this child did quite well nutritionally. So as mother was pulling out of her town with the fresh food in her car, she was stopped by the police. She did not have a driver's license, and she pleaded with the police because she said, "I'm taking this food to my child who's in the hospital in Boston." And they did not arrest her, but had they arrested her, and it's not a sanctuary city, she may have been at risk of deportation. As it is, they towed her car. She pleaded that her pastor could pick up the car. They did not permit that. And all this in the middle of the stress that the child was being transferred to the intensive care unit. So this is bad for this little girl. It's bad for the family, and it's bad for all the other families like them, and it's bad for all the communities where a large number of families have to fear the police. And so that is why, from my perspective, I would wish that all cities in Boston are sanctuary cities. Thank you so much.
Anybody question? Thank you very much for your testimony. Appreciate it. Amy Grunder.
Good afternoon, Chairman of Day and members of the committee. My name is Amy Grunder, and I am Director of Legislative Affairs for the New York Coalition, the Massachusetts Immigrant and Refugee Advocacy Coalition. The New York Coalition respectfully urges this committee to issue an unfavorable report for H 1856. In our view, the main result of this big and likely unconstitutional measure would be to interfere with local government efforts to integrate immigrant communities into the fabric of civil life and to cultivate mistrust and fear between governments and the communities they represent, which was just eloquently described by the me. As already stated by Rep. Provo and others, immigration enforcement is an exclusively federal power. The proposed legislation therefore attempts to punish local governments for failing to act outside their authority. Second, the sanctuary city declarations and policies do not violate federal immigration law, so the bill paints legal measures with the taint of criminality. Sanctuary declarations arose from efforts of faith-based communities to assist people fleeing political violence in the 1980s. And these declarations vary greatly, but generally signal the intent of local government to refrain from participating in voluntary aspects of federal immigration enforcement cooperation. Local policies like these are not only fully compliant with mandatory aspects of federal law, but also build community trust in police and local government and support community policing. We think the main effect of H 1856 would be to further erode the already frayed relationship between many immigrant communities and local law enforcement. While the legal effect of this bill is unclear, it clearly targets the efforts of Massachusetts residents and local governments to welcome and integrate immigrants into the fabric of civic life in our towns and cities. Proposals like this one undermine these efforts by making people afraid to seek protection from local government or police. For example, a 2013 survey by the University of Illinois Chicago found that a stunning 44 and 45% of all Latino participants, documented and undocumented alike, said that fears about police inquiries into immigration status, their own or their families, made them less likely to report being a victim or a witness to a crime. Among undocumented Latinos in that survey, that percentage rose to 70%. This level of mistrust in law enforcement serves no one, and local efforts to repair community relations with the police should be supported and not attacked. And then finally, 1856 interferes with the principle of local governance and the decision of the city or town to refrain from entangling itself with entirely voluntary aspects of a federal immigration policy is a matter of preeminent local concern and ought to be respected. Thank you.
Thank you very much. Thank you for the testimony, appreciate it. Gladys Vega?
Thank you, Mr. Chairman, and members of the Joint Committee. My name is Gladys Vega. I'm the Executive Director of the Chelsea Collaborative, a nonprofit organization in the city of Chelsea, whom many of our community members are immigrants. Our community is 63% of the population is immigrant. We have an incredible relationship with the Chelsea Police Department. In the past, probably 25 years ago, we had to bring in the Criminal Justice Department because of police issues and the lack of understanding and bad practices in terms of law enforcement. That is no longer the case. We're happy to say that we have an incredible relationship with Chief Kais. He has publicly stated that one of the blessings of having the city designated as a sanctuary city is that now the police enforcement are not seen as immigrant agents, they're more seen as local police officers